Welcome to this webinar on diploma privilege and the future of the bar exam. This is being co-hosted by JURIST, which is a legal news organization. We publish legal news and commentary on a variety of subjects, including recently diploma privilege, and actually as far back as April, diploma privilege. We are joined by members of United for Diploma Privilege, which is a national movement of law students as well as others that are working to get diploma privilege for various jurisdictions this year. We do want to thank United for Diploma Privilege for supporting us on this and co-hosting this with us. And we want to thank Pitt Law for hosting as well. So with that, I'll say that I'm Tim Zubizarreta. I'm the managing editor of JURIST, and I oversee our editorial commentary. And I'll pass it to Michael for a second, my co-host.
Hello, everyone. My name is Michael Barber, and I'm the Chief of Staff for JURIST this year. And I oversee a lot of the news writing service and the internal and external staff that we have across the globe.
And we're joined by several members of United for Diploma Privilege, and I'm going to let each of them introduce themselves. So, Efren, do you want to go first?
Sure. Just a quick caveat, my internet connection kind of comes and goes, so if I cut out, please somebody let me know, and I apologize in advance for any technical difficulties. But my name is Efren Hubnell. I'm a graduate from Seattle University School of Law in Washington State, where diploma privilege was granted to us in June.
Donna?
Hi folks, I'm Donna Sadati Soto. I graduated in May from Harvard Law School, also one of the co-founders of United for Diploma Privilege, and so happy to be here.
Pilar?
Hi everyone, my name is Pilares Contrillas, pronouns she, her, hers. Really thrilled to be here. I am also one of the co-founders of United for Diploma Privilege, and I recently graduated from UC Irvine School of Law.
And Vanya?
Hello, everyone. I'm Vanya Smith. I recently graduated from the Catholic University Columbus School of Law here in Washington, D.C., and I am the leader of Diploma Privilege for D.C.
I will note that we were also supposed to be joined by another co-founder of United for Diploma Privilege, Emily Croucher. Emily is having a tough day as a result of Kentucky's recent decision to delay their bar exam, and I'm sure we'll be talking about that at different points throughout this webinar. So Emily is here with us in spirit. But yeah, these are our panelists. I will say, if you want more information on diploma privilege in general, you should definitely check out the recent appearance that the founders of United for Diploma Privilege did on Brian Fry's Ipse Dixit podcast. And Michael will drop a link into the chat for anyone interested in that. You should also check out the editorials that we've been publishing. Several of our panelists have written editorials for us, but we've also had editorials from students and professors and all sorts of people around the country talking about why this subject is important. So if it's all the same to our panelists, I think we'll just jump right in. So I want to start by talking about what are the challenges facing 2020 bar applicants? What are the challenges that are impacting you personally as you try to gain admission into your respective bars?
I can start off if that's good for folks. I think the main one is, structural inequality. I think that a lot of us are really tired today. You'll probably see it on our faces. And Emily, I think, is unfortunately one of today's victims of structural inequality in the legal profession. She, as you mentioned, sorry, I'm sharing my office with my mom, so apologies if you can hear in the background. she, you know, Kentucky decided today that it was going to postpone and that it was going to be a UBE exam, and Kentucky has never been a UBE state. So there are all kinds of additional now barriers that individuals have to face. I think that we are a relatively limited and small number of people who are working on these issues. And so of course that takes a toll emotionally and physically and in every other possible kind of way. I think the real challenge for us is to constantly remind ourselves that this is a long battle and that this is something that we will do for many years. And so as individuals, we may not make the biggest difference right now, but as a collective, that's where the solidarity and the power is found. And any scholar or anybody who knows anything about social organizing and history will know that these battles are centuries long, you know, oftentimes. So that, I think, reminding ourselves of that. Now, speaking more directly about diploma privilege, and I think my co-founders of this movement and Vanya will also attest to the specific issues we faced. You know, there's certainly, we're putting ourselves up against a very powerful institution, right? The bar, the institutions, the bar, the Supreme Court, legislators, and we are relatively ill-equipped. These are not things we learn in law school. These are not things many of us, especially as BIPOC, so I'm going to use that a lot today, Black, Indigenous, people of color. I identify as a Chicana, Latina, a woman of color. Not something I grew up with, knowing how to manage and negotiate a lot of these spaces that we are finding ourselves in, right? So therein lies a lot of the tensions as well. I don't want to take up too much space, but I just wanted to open up by honoring the many people who are lost in these social justice battles because of emotional exhaustion. And we're gonna try to do our best here to, like, you know, speak for Emily, who's taking a little mental health break, which is very much needed. But, you know, we got to keep working on it. We got to keep moving, but this is hard work. So.
Yeah, I think what Pilar said is absolutely right. I think, you know, we've been fighting this battle since March, and we've really learned just how hard it is to go against folks with so much power, and especially going up against an institution, right, against the legal profession that has tradition so deeply ingrained in it that any time that you try to shake something up, you are going to get so much pushback from so many of the key players with power. So we are in fact very tired, but I guess some of the more direct day-to-day, what are applicants thinking, feeling, I think everyone is very just confused. How do we plan for this? And how do I plan for my life, right? So, you know, all of us, or a lot of us, you know, graduated from law school recently, maybe didn't graduate from law school recently, but are seeking admission to our state bar. And now there are a number of different uncertainties that we have to try to prepare for. We don't know if and when an exam is going to happen, and we don't know what that format is going to look like. So we don't know if we need to start building the infrastructure, right, in our house to prepare to take an online exam. And then if that is the case, all of the money and the effort we're going to have to put in to be able to put that infrastructure into place, making sure you have high-speed internet, making sure you have a working computer, making sure you have a quiet, you know, office space or whatever to take this exam. All these little things add up. And then every time that we get this, you know, additional uncertainty, we have all this uncertainty in California, which is, you know, where I'm at and where I'm seeking admission to. We're like, when are we going to start? When are we starting our careers in the legal profession? We have no idea. And trying to plan for, where do we live? When do we sign leases? Am I going to have money to pay next month's rent? When am I going to start having a stable income? We don't have the answers to that.
And I think it's worth noting that some of those things, some people don't have the ability to provide some of those things you've referenced. Some people can't change their housing situation or their internet situation. Vanya had actually written a commentary piece earlier today that talked about some of that. And so I wanted to ask, Vanya, do you want to address that a little bit?
Sure. I think that we've all noted in a number of ways the inherent inequities with the bar examination process that have long existed as a gateway to access to the profession. And what we are experiencing right now is a series of additional barriers that are being put in place that are not testing your competency or your ability to join the profession and practice law. Rather, it's testing your access to resources, your ability to throw money at the problem as things get more difficult over the summer. And we know that everyone does not have that luxury. There are those of us in major cities that are experiencing civil unrest and upheaval that impact how we move about our day. You have graduates who might be working in the service industry, and that industry was very hard hit by COVID-19. And where are they getting their paychecks from? It's certainly not a stimulus check. And so how are we able to navigate an already inequitable structure that has now become a monumentous barrier to access to admission? And I think I mentioned in the piece that one of the things that we are seeing right now is who has familial support that they can lean on, who has a family home that they can retreat to as opposed to their, one-bedroom apartment or their two-bedroom apartment that they're sharing with others who are not trying to seek entry to our profession. Who has the opportunity to get a hotel room for 2 weeks to quarantine in a city where they don't even live so that they can take an in-person bar exam. These financial barriers are stark, and they're causing unprecedented stress in the midst of a global pandemic. And I think that talking about these issues and really speaking up for those that cannot and don't have the access to speak for themselves is why this is so important.
Yeah.
If I could just add.
Yep, go ahead.
There's also the concern of the LLM degree holders that are seeking admission to the bar by way of, so like they're licensed in a foreign jurisdiction, and they come to the US, they do a degree, an LLM degree program, and then they take the bar exam, and that's their pathway to the practice. But they're oftentimes here on visas that require them to work within 6 months of graduation. And this uncertainty could have these people deported deported as a result of not being able to take an exam. So I just wanted to highlight the special considerations of the LLM degree holders, because it's not something that we tend to think about when we think about the person that is taking the bar exam.
Yeah, I think you're absolutely right there. I think that is something that we don't highlight enough, and that's all the more pressing as they're also talking about the recent F1 visa changes. I want to shift a little bit to talk about diploma privilege, as well as some of the alternatives that people have been proposing. So I think first what I'd like is, Efren, you attended the University of Washington, right? Or Seattle? I'm blanking.
How dare you? It's Seattle University.
Seattle University. I'm blanking on your exact university, but Washington State recently got diploma privilege. So I'd love for you to talk about that for a second. Just give us a brief story of kind of what you were aiming for and what you got in the end and how you got there.
Sure. Our advocacy started not long after the movement in California, and actually as a result of Pilar sharing with us a template of a petition to send to our Supreme Court. So an example of that solidarity, our movement got started because of the folks down in California being willing to share their work product. But it was, I think it was March 31st is when we first started having conversations about what do we do about the bar exam? What does that look like? If we can't test, what does that do for us financially? And then the second and third order effects of that. So at the time I was the SBA president, Student Bar Association president. So I reached out to my colleagues at the University of Washington and Gonzaga University. And lo and behold, the same concerns were there as well. So we decided to form our own movement internal to Washington State. And as a student body, law students in Washington State speak as one, and submitted a petition to the court, a letter of intent to distribute petition outlining, hey, we're asking for diploma privilege for these reasons. And our request was kind of vague intentionally because we didn't want to call into question, okay, what about out of state test takers, people coming from non-ABA accredited law schools? All three in Washington are ABA accredited, and nor did we want to call attention to various other or like repeat test takers. We didn't have an answer to that, but we kept our request deliberately kind of vague, so that way we could answer those questions as they came up. But initially the proposal was shot down. So the initial request went up in April 17th. The conversation was renewed in the wake of the murder of George Floyd. I think is Vanya, right? I'm saying that correctly? Not Vanya. Okay. As Vanya said, you know, Seattle is one of those cities that did experience a decent amount of civil unrest as a result of the murder of George Floyd. And Seattle University is seated in the heart of Seattle, where a lot of the unrest was. In my own apartment, I had to leave Seattle several times over the course of a week because tear gas is getting into my apartment. That is not an ideal situation to be studying for a standardized test. So in response to all that was happening, the court indicated that or the court released a letter basically acknowledging its role in systemic oppression and racism. And so my university faculty came together and said, we need to send a letter to the court basically telling it to put its money where its mouth is. And they did that. And so the letter was transmitted on a Wednesday. By Friday, they were reconsidering diploma privilege and decided, voted 7-2 in favor of it. Now, this version of diploma privilege is only extended to registrants of the July and September UBE, and only if they are graduates from an ABA accredited law school, and to the exclusion of our LLM degree holders here in Washington State. So that is the population that we are targeting our advocacy in support of, because there is no plan for these people, especially given that July may not happen still. What do we do with these people then?
Yeah, I think that's really important. I think it's important to highlight that it wasn't successful initially, that you had to continue advocating, and more than that, that you're still advocating now for the LLM students even after having achieved diploma privilege. So now I want to talk about some of the alternatives, right? Because there's lots of jurisdictions are treating this very differently across the board. Some of them are talking about delaying their in-person exam, you know, hoping somehow that things are better in the fall. Some of them are talking about remote exams administered online. Some of them are talking about provisional licensure or things like that. What do you think of these alternatives? Why are you advocating for diploma privilege over some of these alternatives that are being proposed?
Diploma privilege is the only equitable solution, given how much is tied up in what this test does for us. We didn't ask for the conditions that we have inherited. We came to law school, we signed up for law school knowing we were going to go into debt up to our eyeballs. We knew we were going to be out of the job for 4 months while we studied for this god-awful exam. And now the bar is being moved in various ways in various jurisdictions. There's no easy way to go about, once you start messing with the bar exam, there's no easy way to fix all the complications that arise from that on the individual level. So diploma privilege is the only way that you can get around that uniformly, I would say. There's an interesting model in Utah. They are not calling it diploma privilege, I don't think. It's kind of a provisional licensure contingent on so many supervised hours of practice in the first year. So I would highlight that is an alternative that could work, but that's not necessarily at the core of what we are advocating for. But I do want to note it because diploma privilege is a really broad concept, and the name is awful. Let's just acknowledge it. There's very little privilege in being able to do the job that you signed up for. So I just want to highlight that diploma privilege can take many forms, but essentially what we are saying is that the bar exam has no place in all that is current events right now.
Yeah.
I think, yeah, go ahead.
I'm so sorry, Efrain. I guess the only thing I'll add is that it's funny, everyone thinks this is law students who just want to get out of an exam, or recent graduates or whomever, but let's not forget who actually advanced this as a viable option first. I mean, not to mention, obviously, Wisconsin in the 1970s, but it was 11 law professors who released a white paper on March 22nd 2020, and it's called The Bar Exam and the COVID-19 Pandemic, the Need for Immediate Action. And I'll put that in the chat right after I speak. But this was, it wasn't actually initially proposed by law students at the time. Professors with cumulatively a lot of experience in legal education, a lot of knowledge about the practice of law, went down provisional licensing, postponement, what an online an online administration could do, and found that all of them were in fact pretty inequitable, and would more negatively affect certain groups of students with families, students who are at non-accredited law schools. That's something that we're dealing with in California, where a lot of folks, mostly BIPOC, mostly people with families, do choose, and it's a choice, right? They could have gone to an ABA accredited, they made a choice for funding purposes and also the flexibility of a program to go to a non-ABA accredited. So there are, I just want to put that out there, that this movement really began because it was professors who acknowledged this need and made us feel like we could take this take this advocacy on our own. And this paper is brilliant. It's great. It brings up a lot of points about why provisional licensing doesn't work. I'll let someone else maybe come in to talk a little bit about provisional licensing. I want to highlight that what seems to be a very fair alternative is an online administration. Speaking to the solidarity question, when we decided to continue moving forward with this movement in California, I reached out to Efrain. Efrain was like, in solidarity, we worked on through your letter, here's our impact survey that we sent out to Washington that allowed us to collect a lot of demographic data, a lot of information about test takers that ultimately swayed the court. So we did the same thing in California. We added a few questions related to online administration and found that only 25% of students feel comfortable taking an online exam, or have the required internet. And I too am struggling with internet. I think all of us probably would be booted out of an online administration at some point in those 2 days, just given the power outages, the outages of internet that are happening with Spectrum and all of that. That's not even to mention how ExamSoft, which is what many of these state bars are thinking of using, will utilize a vendor that does proctoring that's not human proctoring, that's AI. So just like a fun fact that one of my colleagues told me about not too long ago was these AI proctoring machines are they absolutely reflect racialized bias. So 9 out of 10 times, if it's a white male whose face they're reading, it will be a successful read, right, of the face. For a Black female, that's like 5 out of 10 times. So this is racialized, it's gendered. Many people have talked about how AI has negative effects on students and people of color. So, even what we think of as a rational, non-racist approach forward does highlight all of the crevices in the system, all of the cracks in these systems, right? So online is not, in fact, a viable approach.
I also would add that the information we're getting from the various jurisdictions regarding how the online test is going to be administered is a problem in terms of how we have been preparing to take a bar exam up until this point. People who are fortunate enough to pay for a bar prep program like Barbary or Themis or whatever have been taught certain test-taking methods that we will not be able to employ. You will not have a test booklet where you can write margin notes. You cannot highlight, you cannot underline. There's no scratch paper. You will not have an opportunity to, as I put it, draw my little diagram so I can figure out subject matter jurisdiction. You can't do that. And so we are being asked in the middle of the summer, in the middle of a pandemic, in the middle of civil unrest, to learn how to take a test that we've been paying to try to figure out how to master for the past several months. And that speaks nothing of those students with accommodations and disabilities. There has been no discussion of how those examinees are going to be accommodated with an online exam in their homes and being tracked by artificial intelligence. And so it seemed like the quick and easy approach. And every time a jurisdiction said, we're going to go remote, there was about 5 minutes of rejoicing. And then all of us started raising our voices and saying, no, 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 that's not equitable. It's not going to work. That's not the solution.
I just have one more thing to add. So yes, absolutely second, third, all the concerns about the online administration. For California folks, you may have heard today that some of our legislators are thinking about an alternative called provisional licensing. So I just wanted to talk a little bit about that alternative. So there's kind of talk in California around diploma privilege versus provisional licensing. I think there's a misunderstanding of what those two mean. You know, diploma privilege being when you graduate from law school, you are admitted to the state bar in your jurisdiction, versus provisional licensing as is being advanced by legislators in California is you're going to get a temporary license to practice. And then when we can take the bar exam, you take the bar exam. And that's how you get admitted to your jurisdiction. So it doesn't mean the bar exam goes away. So just wanted to note that that's an alternative and wanted to really highlight and underscore the disruption that comes with that pathway, right? So, you know, maybe you get to start your job and then in a few months, you're going to have to ask them to take time off to study, right? The 2-3 months to study for the bar exam. Maybe they won't give you the time off. If they give you the time off, is it going to be paid? How are you going to pay your rent? And look, it might just be the case that a lot of folks aren't going to want to hire you if they know that you're going to have to take time off to take the bar later. Or maybe they'll absolutely just rescind your offer. So it's not a solution. You know, we have been we spent the day pressing our legislators here in California to adopt diploma privilege, not provisional licensing, and to advocate for that. So I think the disruption that comes with the provisional licensing piece is huge.
And if I could also mention, there's a very real timeliness issue here. Beyond our individual concerns as would-be bar takers and would-be lawyers, there's a need for us to be in the public sector working. As far as, I don't know how every jurisdiction is handling this crisis, but in Washington State, we've suspended jury trials for over 3 months now. These cases cannot just not be heard. At some point, they're going to have to go before a judge, go before a jury, and be tried. That's going to require prosecutors and public defenders to bring these cases through the court system. And I don't know how the other jurisdictions are, but I know in Washington, turnover is very real for public defenders' offices and prosecutors' offices. They depend on that fresh crop of people graduating from law school and being admitted to bar and then joining their ranks so that they can get these cases tried. Without diploma privilege, that doesn't happen on time.
Yeah. And to add to that, one thing we're seeing in Washington, D.C. Are COVID-related issues in terms of evictions and other civil rights issues that are popping up now that are new, and access to pro bono work and access to pro bono volunteer attorneys. That work falls to first-year associates. That work falls to you know, the entry level, the brand new lawyer, and that's limiting the access to justice for those in the communities that need it the most.
Yeah, so I want to highlight a couple of things here. One thing I want to highlight is diploma privilege is not new. That's something that I think sometimes gets lost in these conversations is, you know, for a profession so steeped in tradition, we forget that diploma privilege was the norm 100 years ago. Like, it only 100 years ago did we create this entire bar exam infrastructure. And if you want to read more about that, I will also drop into the chat. The Jurist e-board wrote an article specifically on the history of diploma privilege and why it's something that it makes sense for us to go back to now.
Yeah, Tim, just to interrupt you, I'm keeping track of all the links and a lot of things that we're referencing about resources, and I'm keeping a list. And towards the end of the presentation, I'll make sure that I repost all these links. Just so everybody has them at the end, so the conversation that's taking place in the chat can continue.
I'll actually say I think we should do one better. I think we should post that on our site somewhere. We should post a wrap up of the webinar that includes all the links that we've referenced.
Yep. And actually now might be a good time to throw out some of the, we have a question that's been submitted. Some folks are interested in the panel's take on what's happening in Illinois, and they were wondering if you had any comments on the steps that the Illinois Supreme Court has taken recently in ordering the Illinois Board of Admissions to respond to the petition for diploma privilege. And we were wondering what your thoughts were on that, whether you had any idea what may come of that, what the responses might be.
I just want to say on behalf of Emily, you know, that's the kind of push to get an answer that Kentucky needed. There are too many bar exams that are scheduled to happen in the next 14 to 17 days while, you know, folks are still in limbo. And to go through the mental gymnastics of studying in earnest for something of this magnitude for months, and then to physically move yourself, because a lot of people have had to chase an exam. A lot of people have had to register for exams in other jurisdictions just to try to get a UBE score. And so to have uprooted your life and perhaps that of your family, only to get there and then find out within 2 or 3 weeks of the most important exam of your life that it's not happening is completely unconscionable. And to think that that is going to be so many 2020 graduates welcome into the profession is, it's just mind-boggling.
Yeah, I kind of have a related question here that I think is probably best addressed to Efren. Someone in the chat had asked about recent pushback that the Washington Supreme Court has been getting with their diploma privilege decision, where some employers are saying they're still going to require their new employees to have taken the UBE. Do you have anything to comment on that?
Yeah, overwhelmingly, employers are bringing on folks that have been admitted by way of diploma privilege. That is a concern that is only coming up as far as I've been able to keep track of. That concern arises when you're going to a private firm that does the sort of work that requires you to be able to litigate a case prepared in another jurisdiction. So there are some firms that, by nature of their work, it just makes sense for them to require a UBE score. But overwhelmingly, even I think Perkins Coie, to name drop, which is a very large and well-known firm, they are bringing on first-year associates that are admitted by way of diploma privilege.
Kind of related to that, something that I also think doesn't get talked about very much in this, or hasn't been talked about very much generally, is reciprocity. Do any of you have thoughts on the idea of how diploma privilege should have, like how states should approach reciprocity where someone's been granted diploma privilege in one state but has an interest in practicing in multiple states?
So the last I saw, I think 31 or 33 jurisdictions that have a form of reciprocity or comity don't got left first place. All they will be is 3 to 5 years.
Efren, we seem to be losing you a little bit.
Remaining, math is bad. 17 or so. Oh, all right. Am I back?
Yeah, we
Yes.
had lost you for most of that. If you want to try and say that again.
All right. I was saying, I think there's 31 or 33 jurisdictions that if they offer a form of reciprocity, they don't care how you got admitted to the bar and where you're coming from. They just care that you have a law license and you've been practicing for 3 to 5 years. Of the remaining 17 or so, they do have language that specifically requires, if you were admitted by way of diploma privilege, you need to take a bar exam. How that moves forward now that we have states adjusting, like the state of Washington, I would like to see some language coming out of like Oregon, for example, now that they have also instituted diploma privilege, allowing for immediate reciprocity, because there's a very real need for lawyers that can work in both marketplaces.
I also personally encountered an issue. I originally was I applied for the DC bar because that's where I live, that's where I plan to practice. But when the bar exam was moved to October and online, I applied to take the test in New York because I wanted the portable UBE score. And so as things evolved, I made a plan to sit in New York in September and in DC in October, just in case there were any reciprocity issues. And then last week, we find out via the DC bar that that's not permitted. And I'm not the only one that did that. So I have paid for 2 exams and I can only choose one. And so I have to take the DC bar because that's where I live. But I had planned since first year of law school, just based on what I want to do career-wise, to be admitted in both Washington and New York.
Yeah, I just want to underscore that point because I went to law school on the East Coast. So a lot of my friends, colleagues, peers want to practice on the East Coast. It's, you know, it's not just the diploma privilege issue of whether or not that's going to be reciprocal. It's even jurisdictions that have changed to an online administration are going to have issues right now with reciprocity. They're saying that, you know, you can't use that score elsewhere. So I think like jurisdictions need to get it together and recognize that folks, you know, even if their short-term plan is to be in one state, they thought that long-term they would have more flexibility. And now it seems like that's not the case. And that's really upending a lot of the plans, especially for the folks on the East Coast, especially Anya, the DC, New York folks, right? Or Massachusetts folks. It's really just impacting what their short and long-term goals were going to be in the legal profession.
Shifting direction a little bit, there's been some...
Let me jump in, actually. We have a couple of questions that sort of go together that are coming up. I don't know if you've seen in the chat, but we have one question in asking about accommodations for online exams. And that sort of also goes along with a point that you might have seen AJ post earlier. AJ is a member of the board of the National Disabled Law Students Association and DLSA. And that was actually a question that I actually wanted to ask specifically was, what sort of advocacy is taking place for students that might need accommodations on bar exams, and how is Diploma Privilege giving them a voice, and how are you elevating voices of those that need accommodations? And that sort of goes along with the question that came in through the chat, which was a question about online exams and what sort of accommodations are happening there with things like mid-exam breaks and those sort of things, if you had any information on that.
Yes, that is currently being addressed in the DC petition to the court. We anticipate that petition will be filed no later than July 15th. But in the section where we talk about sort of the day of concerns that we have for the actual sit-down administration of the online bar exam, we talk about breaks and whether or not, you know, if you have a condition that requires that you need more time, or how are those accommodations going to be met. Also, we've received some data about how the AI software may interfere, may give you a false read, as it were, if you have any sort of physical movements or things that are completely natural and just inherent to who you are, that might be related to a disability, but the AI software is going to read that as potential cheating or some other issue. So that is addressed in our petition.
Did you have any other questions you wanted to jump in with here, Michael?
Sure. Yeah, there's one other that's come in through the chat, and it's just to hear your thoughts on the New York State legislation that's been proposed by Senator Brad Hoylman in the last 2 days. I'm not familiar with that legislation, but I'm assuming it's related to diploma privilege, and I don't know if the panel's aware of that fairly recent legislation that's happening.
Yeah, so we are aware of it, and part of the movement has always been to engage legislators. At least in California, that's been the case. I know Washington had a very different experience because of the politics between, you know, the arms of government. In California, it was very clear very early on that we would need to achieve buy-in from our legislators. And so from the beginning, Donna and I were emailing, CCing a core list of about 15 legislators on the Judiciary Committee, on the Appropriations and Budget Committees, and just letting them know what we were doing and that we were making some noise, right? Respectfully so, but making some noise. And so those communications have been occurring since late March. And we feel as if there's been some validation because it's just now that these legislators are starting to listen to us. We didn't go straight into, I think because we started very early, frankly, we started this 4 months ago, so we didn't go straight into asking any legislators to introduce bills. We are now in that place. That's exactly what we're doing. So the legislators who we have been communicating with, we had, a massive call-in day yesterday. I think almost 1,000 phone calls were made in California to key players, and tweets and emails. I mean, it's been a serious part of our activism and advocacy here on out. That's kind of our next big step, is to try to get folks. We've been, contacting the Supreme Court. We've asked about 5 times for a hearing, and every time it's rejected. So now it's kind of like all bets are off. We have to go hard, and we have to contact our legislators and let them know that their constituents are angry and that the state bar is not being transparent and the Supreme Court is not hearing our pleas. We've been imploring them. So we are aware of everything that's going on in New York. There is a United for Diploma Privilege chapter in New York. We communicate with them. And we're doing the best that we can in California to try to follow that lead. And luckily, we at least can say that there are other states where this is now happening. So we're not kind of like, our legislators don't feel like they are making some extremely brave decision for a radical shift in licensure.
I just want to note for folks in different jurisdictions, if you see legislation pop up, I guess to pay very close attention to what is in there. I think something that we are dealing with today in California are the specifics of what our legislators are advocating for. And in California, specifically, like what we think then they might introduce if they're going to introduce legislation. So pay very, very careful attention to who gets included under their scheme for diploma privilege, or what we learned in California today, fake diploma privilege, right? It was actually provisional licensing. And, follow up with your legislators if they're not being inclusive, if there's language in there that's misleading, then let them know, tweet at them, email them. We organized a great campaign yesterday, a call-in day right here in California to your legislators. Everyone was just mass calling and emailing legislators. That sort of got the ground running. Our work is still very much cut out for us. We, still need to be focusing this week and next week on tweaking the position of our legislators, but just be very careful for what, folks advocate for and what they're putting out there, and don't give up. You keep pressing and pressing to make it as inclusive as we can make it.
Yeah. Yeah, that makes a lot of sense. And I think it's good. Like, it's good that you're doing that advocacy. It's good that you're taking those issues into account. Semi-related to this, I know that the NCBE, the National Conference of Bar Examiners, has been very opposed to this movement. And one of the criticisms that they've leveled against it has been that it would be conflating the role of law schools and state bars, having law schools take on the responsibility of licensure almost. So my question is, does it unfairly conflate those things? And what do you see as the proper role for law schools and state bars and even the court or the legislature in terms of bar admission?
Perhaps that's a question you should ask Judith Gunderson, who heads the NCBE and who herself is a beneficiary of diploma privilege. But taking your question seriously, Tim, I think it's appropriate to throw some shade, because it's absolutely egregious and hypocritical for an institution, which, by the way, is mostly white male led, and whose folks who work there are mostly, you know, white men, who themselves have released reports acknowledging the disproportionate impact on certain communities, students with disabilities, women, you know, it's a sort of throwaway, right? Like women, people with disabilities, people of color, which actually is no longer the minority in the world. Like we actually make up the majority. But anyway, it's completely disingenuous. I think I respect your question, but I think that the problem is, you know, that there is a hypocrisy, right? Like the whole reason law schools, if you look at the history of why law schools emerged, they were exclusionary. If you look at the history of why ethics and the moral character application emerged, it was exclusionary. It's because 3 Black men accidentally made it through the ABA in 1912, and this resulted in an identity crisis for the entire legal profession. So that's also when they started gathering demographic information. Funny note, right? We like to think that we love the fact that the profession and state bars gather demographic information about us, but it in fact started because of a racial fear and a racial project. So I think that, you know, more people need to be asking Judith Gunderson. We've tweeted her a few times. She doesn't have many followers, so I think we can all show her a little bit of like love and support after this call and continue tweeting her and asking how she can, in good conscience, in good faith, in fact, promote an inequitable path to licensure when she herself knows nothing about the, you know, difficulties of having to prepare for such an exam.
Yeah, and I want to say that I did kind of set you up there a little bit.
I know, you totally wanted it, didn't you? And
I wanted to give you an opportunity to respond to it because you get lots of these criticisms, right, that aren't really founded on meaningful truth. They're just criticisms that people find easy to throw at it. So I wanted to give you an opportunity to respond to that.
Thank you so much. I needed to let some of that aggression out, Tim.
Yeah. Yeah. So related to that, I think it's a good time to talk a little about advocacy and about how the various graduates and professors and really anyone else that wants to help contribute to this movement can start to do that. I think I want to start with kind of the most important ones first, though. We've mentioned a couple times that there are still a few states that are holding an in-person July bar exam. What suggestions do you have for applicants that are in that position where their state is still planning an in-person bar exam? How can they advocate right now? Anyone?
I mean, I think that's a tough question because first and foremost, it's absurd that jurisdictions are holding in-person bar examinations in 2 or 3 weeks. It's absurd, but it's happening in some jurisdictions. I wouldn't be surprised if other jurisdictions follow Kentucky and in the next coming days are like, no, we can't hold the exam this month, right? Like these in-person examinations should have never been scheduled to begin with. They really shouldn't have. And it's absurd that they were. But nonetheless, I don't want to tell folks like, oh, take away all this time from your studying and like focus on doing this because it is a lot of work. But for those folks that really want to, I think one avenue is really pressing your legislators and leveraging a lot of the information, data, and actions that your legislators are doing in your state related to COVID-19, right? Like a lot of massive states are back on lockdown or they've shut down or there are restrictions because we realize that, not sure why all of a sudden we're realizing this, we're still in phase 1 of COVID. We haven't even gotten to phase 2. COVID's not over, it never went away, right? And so, being able to leverage legislators and other folks that are really involved in making sure that we keep our public safe and appealing to them because this is a public health crisis. I mean, you're going to have folks gather in person in a massive venue Some folks have to wear masks, others don't even have to wear masks during the duration of their exam, right? Like all of this is incredibly dangerous. It's not fair to folks that are immunocompromised or live with immunocompromised folks. Folks are gonna get sick. Folks are just gonna forego taking this exam or have already forgone taking this exam because they're not gonna risk their lives for this. As important as entering this profession is for us, you're not risking our lives and the lives of our families for it, right? So, you know, really appeal to your legislators if you have the capacity and energy to do so, because it truly is unethical that they're holding those exams in 2 or 3 weeks.
And I think I 100% want to echo what Donna is saying here, but I also want to, I think it's important to qualify this statement as well, that when you start advocating for your jurisdiction, for your cause, be very careful how you go about attacking the bar exam. If you are talking, especially if you're talking to your bar association or your Supreme Court, it is their baby. They get really defensive really quick. And when they get defensive, they stop listening. So, you know, you can start off with a petition and maybe you go to a hearing or something, but I would lead with everything Donna just said. It is unethical to have a bunch of people come together in the middle of a global health pandemic.
Yeah, I think. Oh, I think we lost you.
I think you lost me.
Yeah, we did lose you a little bit.
I was just going to add, I echo everything that was just said, and I also was going to add that, you know, we started this discussion by saying that this is going to be a marathon, not a sprint. Like this is going to be a long-term thing. Systemic change does not happen overnight. And I think focusing on what the immediate need is right now. We all know about all of the inequities with the bar exam that have existed since the bar exam was initiated. We know why it was created, but now is not the time to attack the integrity of the bar exam or whether or not there should be a bar exam. Now is the time to deal with 2020 and lead with the problems that make 2020 unfair, that make 2020 inequitable, that make 2020 unconscionable to give the exam. And then once we get past July, September, and October, and we are lawyers, because I believe we will be, then we can go back and do the type of advocacy that makes the change that we all seek. But I think you're going to get a lot of doors slammed if we're focusing on trying to dismantle from the very beginning. I think our strongest argument is what we are dealing with right now as a country and as a world, and then we can attack the bar exam and bury it once and for all.
And I do just want to make one quick plug. So if folks need resources, right, templates for things, you know, we had this big document for our call-in day yesterday around like with scripts of what to tell your legislator. UnitedForDiplomaPrivilege.org has a lot of just templates that you can use, right? A lot of this movement, I know there's a lot of individual activity going on in jurisdictions, but we are a national movement, right? This is a movement of solidarity. We leverage what folks have put together where we can, so we're not reinventing the wheel. So some of those resources are available for folks if you want to leverage them, and they're on the website in the resource library.
I also want to highlight that social justice happens in a lot of ways. And so while, for example, Donna and I in California may not be, when we're speaking to the Supreme Court, we may not be speaking the language of abolition. When we're writing op-eds, we are. When we're talking to some of our legislators, we are. And with other legislators, we're not. So part of this is actually being very nuanced, and you got to be an anthropologist. You have to be able to read people, read the room. You know, like there's not one talking point, because for us, when we talk to the court, we're very deferential. We're very sort of accepting of the bar as everyone's, you know, acknowledgement that we got to go through this ritual. There are problems with it, but let's put that aside. When we're talking to legislators, we are going in on the racism of it. We're going in on the disparate impact on BIPOC students. We're going in on all of these issues because that has currency with legislators. So I think it's valuable to note that like there is no one right way to do this, right? And also students or recent grads who are located in the South and who are facing some serious silencing mechanisms, we've gotten emails from students who have acknowledged that, you know, people have basically said to them, no one's going to listen to you. You're from a historically Black university. Like, flat out have said that to students. We're not dealing with that in California. There's a lot of racism in different ways here, but, you know, that everyone's sort of differentially positioned. And so to connect that with what Donna is saying, please reach out to us. You know, we are trying to refine like an onboarding team so that we can set you guys up with a Google Doc. We can help you start doing some of this writing. You're not alone. One woman who's a member of our coalition is handling Tennessee and Alabama, you know, because she's graduating from school in Alabama, she's graduating from school in Alabama and all her friends are there, but she's moving to Tennessee, so she cares about both, right? People are just doing this out of love. Like, this is a total love ethic, so you have to like kind of trust in that and dive in it with us. But please don't feel like you have to silence yourself, or there's ways, you know, there are ways to navigate, and there's a way for your voice to be heard in different approaches, you know, like just the Supreme Court tends to be very conservative, and the bars as well.
I know we've hit our time, but if it's okay, I'd like to go a few minutes more. But for anyone that does need to leave, we are recording this and we are going to make this publicly available in several different places. I also want to note, kind of related to what they've all been saying, you know, this is something that's going to take a while. This is something that's not going to happen overnight. And so I think it's important for people that are advocating to also take their own mental health breaks, you know, do the things that you need to do for you, because this isn't something that's just going to happen all at once. You know, we all of us on the panel definitely sympathize with Emily needing a mental health break today. I want to ask about this. This is probably this is a slightly more disheartening question, I think, for some of you. We've been hearing a lot of reports at Jurist about jurisdictions that are trying to pressure their students not to raise these issues, jurisdictions that are, you know, either employers threatening to reject students, or jurisdictions that are actively talking about weaponizing character and fitness to keep students out of the bar for advocating. Do you have any comment you'd like to make about that?
I think if you're, well, I will say that I'm not speaking as a person who's experienced this. I've not been contacted by our state bar, and I don't think Donna has either. So this isn't something we're facing. We've heard about it, and we know that this is occurring in some smaller jurisdictions. And there have been, you know, communications via Twitter telling folks that they need to step back because the chief justice of a particular court feels some kind of way. You know, like, there are all these dynamics that we don't know. I haven't experienced, so I can't speak to it. What I will say is that part of this is why solidarity is important, because we do rely on each other for emotional support, and we rely on each other to talk through particular issues we're facing, or how we can navigate them in a better way. But this is, you know, no fight is ever easy. No fight is without casualties. And I don't mean that in a sort of like, we lose people in the fight, but I mean like, you lose parts of yourself, you lose time with your family. You know, the last time I had dinner with my parents and didn't look at the phone to think about Twitter or think about an email was several months ago. You know, I'm like back and forth between Irvine and visiting my parents, but these are not fights that are easy, and that's why it takes a toll. So people should know. And I guess the other thing is, it's okay to not take on this fight. If you don't have it in you and you have a July exam and you need to focus, and, you know, especially, I want to say this, especially for first gen, college grads, first gen, everything, like, it is okay for you to decide that for your own well-being and for the well-being of your family, you're going to focus on studying and putting those 10 hours in. So nobody should feel like they have to because of some cause. You know, the cause will be here forever. And I have to keep telling myself that, because I'm bad with boundaries. So if you're bad with boundaries, like, just know right away that that's something you think about.
Yeah, I think the bad with boundaries probably applies to most of us on this panel. But does anyone else want to comment on that before I ask what's probably my last question? Okay. So my last question, a little more optimistically, is, you've all probably studied bar admission a whole lot more than than the 10 generations before you. What do you think is the ideal method of admission to the bar, the ideal method of license to practice law?
Well, I think I'll start. Definitely not a bar examination, but I do think we need to look at what our clinic requirements are. I think the practical hands-on knowledge that you get of how to do this thing by participating in clinic, and also the added level of compassion and heart that it exposes you to speaks far more volumes in terms of your readiness to join the profession and your character and fitness than a written rote memorization exam. So I would be interested in increasing the clinic requirement and making some sort of clinical education a requirement.
I'll second that. I did a 2-year clinical program in law school, so I had clients for 2 years. I learned so much more from a week of having clients than what I learned all of 1L. You just learn so much more, and it's practical and it's applicable. And, you can join a clinic in something you're actually interested in, right? Like, we're supposed to learn, right, all of these different subjects for the bar. We're not going to practice in all those subjects, right? Some people are just really interested in a particular thing. I love immigration law. My bar exam doesn't test immigration law. I don't imagine I'm going to be doing all these subjects that my bar exam is trying to test me on, because I want to focus on immigration law, right? So, having the flexibility to choose what interests you, what's going to be helpful for your career path, right? The legal profession isn't a monolith. People do a lot of number of different things within the legal profession, and you can pick in law school what's going to work for me and what do I want to learn. So clinical requirement, have that be a little bit, broader than you have to do a particular like one-on-one direct client services. Some people are like mediation or negotiations or whatever. So whatever that looks like, do that in law school and have that be, the mechanism that shows that you're ready to enter this profession.
Yeah, I mean, I'll say I'm a rising 3L at Pitt Law, and I'll say that, that is something that I find odd about our curriculum is we're only allowed 4 credits of externship credit, 4 credits actually working for an outside organization. And I agree with you. I think there's a lot to be said there for encouraging more direct work, whether that is through clinics that the school runs or through outside organizations doing something, training you for however you're going to practice. Does anyone have any final thoughts they'd like to say?
I would like to say, direct everyone's attention to the chat. I've kind of dropped in some links here and there to some of the information that we've discussed here tonight. And we'll try to make sure that wherever this video is posted of this webinar, that we'll include those links as well. And I'm really grateful to have this conversation with everyone. I couldn't have asked for a better panel to discuss this issue of some active, passionate, highly qualified, soon-to-be lawyers. And I want to wish everyone that's currently studying for the exam good luck in your various jurisdictions.
Yeah, I want to echo Michael's thoughts. I really want to say thank you to all of you for attending. Thank you to our panelists who, provided some very clear, cogent, and in some cases emotional thought on this subject. I think this is an important discussion for us to have. So I really can't thank you enough for making the time to do this. And again, I'll thank Pitt Law for helping us host, and Jurist, where we both are from, and United for Diploma Privilege as an organization for helping us put this together.
Can I just offer my own thanks on behalf of our org? I mentioned this before everybody joined, but you know, as this gains a lot of movement, we're getting a lot of press requests, you know, and it was funny because we reached out to all of these people months ago, and nobody heard us and nobody listened, and Jurist did. Jurist allowed us to make numerous, you know, Tim was great. We wrote so many op-eds, and it really helped us to get the point out there. And I also want to say, please always lead with your heart and let that be in service of your mind, and vice versa, right? Like, don't ever lose faith, don't lose hope. This will be a long-term project, and you have to believe in the solidarity that you have cultivated with your fellow classmates, with your future clients, with the people. We're not just doing this for ourselves. We didn't even get into like our clients, and that's what really drove Donna and I to do this, is because Donna was in, you know, in immigration clinic, and I am going to be a public defender. And so there are all of these ways in which we just saw the immediate suffering that was going to result. And so never forget why you came into this profession, despite all of this craziness that we're seeing. I'm sorry, that's not the right word. Despite all of this nonsense, and very well curated architecture of exclusion, right? Don't forget that why you're doing this and who you're doing it for. So thank you all. We appreciate you. And thank you to Tim and Jurist.